attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning.
SJC-12818, SJC-12792, OE-142, Arthur Burnham v. Commonwealth.
Mr. Burnham, good morning. We can see you, but you should sit because if you stand, we could not see your face. So you've got 10 minutes, and I gather that the clerk will give you a 3-minute warning when you have 3 minutes left. So if he won't, can you see him? Or can you only see me?
No, I can see the justices and I can see the clerk.
Oh, you can, okay. So he'll give you the 3-minute warning, and if not, he'll motion to me and I'll give you a 3-minute warning. All right, you may proceed, sir.
Thank you, Your Honor. Good morning, Your Honors. First, I'd like to start by stating that having learned law from within a cement cubicle, today I find great joy and privilege to stand before the court and have an opportunity to promote the evolution of law in regards to the initial review collateral proceeding. I have conferred jurisdiction upon this court, and through the United States Constitution's Supremacy Clause, Article 6, Clause 2, I believe it is the duty of this court to say what the law is in regards to the advisory mandamus, and please consider giving force and effect to the applicable constitutional provisions in which the Martinez versus Ryan court failed to address the constitutional issues and instead chose an equitable ruling. Today I'm seeking the justices, please consider the constitutional questions in regard to the state's use of Rule 30B as an initial review proceeding. But first, I got so much here, but I'm going to have to address the 211 Section 3s that got me here. SJC-12792, the single justice dismissed this. I believe this was an error of law. I'm going to speak quickly. So the petition clearly stated the denial of a substantive right. Applicable principles at paragraph 6 state that there is an intentional and egregious misconduct attributed to judges, clerks, and prosecutors in the plaintiff's criminal prosecution. The government bears responsibilities for remedying the misconduct. Paragraph 8, due process requires a neutral and detached decision maker in the first instance. Paragraph 9, the extrajudicial source of the plaintiff's ADA damage claims against Worcester Superior Court, but the alleged misconduct is so extreme to display clear inability of the original trial judges to render fair judgment. The justice didn't offer an opinion. In ADA Sullivan's brief, she simply states that the defendant's recourse to vacate his guilty plea, and if denied, if he's dissatisfied, is to seek further appellate review. She further states that because the error complained of in the defendant's petition is for extraordinary relief, a remedial in the normal course, that the appellate process, that it was probably denied. The ADR's argument fails because the remedial criminal process is not normal. The surviving accounts of the ratification debates support that conclusion, Your Honor. 2008, Bumedine versus Bush Super at 742. I'd like to quote some of the framers here during the finality era cases. The framers' inherent distrust in government power was the driving force behind the constitutional plan to allocate the powers among 3 branches of government. This design not only serves to make the government accountable, but it's to secure liberty. Let's see, quoting Loving versus the United States. Even before the birth of this country, the separation of powers was known to be a defense against tyranny. Justice Jackson, the Constitution defers its power to better secure liberty. So, in this case, Your Honor, I'm alleging that undivided, uncontrolled power of government bear down upon a self-represented threat defendant in open court, under court audio. That's not a normal situation. And as I've stated in my brief, it's an abortive proceeding. For the single justice to allow me to go back in front of the same abortive proceeding doesn't comply with the demands of due process, Your Honor. To date, I've been in Rule 30B process, no transcripts, no trial whatsoever. Why should I have to wait 1 year in an unconstitutional collateral proceeding with no rights to counsel, no rights to transcripts, and then after a year, oh, I can appeal after a year? Well, this is not what the framers had in mind in this situation. I'd like to quote to you a resolution of New York, the ratifying convention of 1788, noting the convention's understanding that every person restrained of his liberty is entitled to an inquiry into the lawfulness of such restraint and to a removal thereof if unlawful, and that such inquiry or removal not ought to be denied or delayed. And here, Your Honor, there's grave issues of separation of powers. Here I sit at a year, I have no transcripts, I have no way to properly defend myself. I believe that contravenes what the framers had in mind when they decided to allocate the powers of government into 3 different branches. So also at issue is the single justice should have considered the circumstances and the relationships, the pecuniary interest, because I did file ADA damage claims, and also the vilification. Okay, the original trial judges and clerks, prosecutors have been vilified by this petition as oath breakers, and are now parties to a bitter controversy with pecuniary interests. There is precedent for this. There is precedent for this. Toomey versus Ohio. Also, requiring Mr. Burnham to test the legality of this conviction by returning to the same forum, as I stated, violates the protections of guarantees of due process. And according to James Madison, the Federalist, number 10, page 59, quote, "No man is allowed to be a judge in his own cause because his interest would certainly bias his judgment and not improperly corrupt his integrity." I believe the justice failed to take into those considerations. Rule 30B in front of a vilified court where pecuniary interest, Your Honor, is not appropriate here. There needs to be another proceeding. Also, I'd like to note that the ADA never rebutted the delay on the Harris versus Champion, never stated nothing about the abortive proceeding argument that I made, Thurn Fay versus Niowa. I believe that is a winning argument. I believe there's a break in the appellate chain below. As far as 12792, 12818, the ADA damage claim that I filed under the Constitution, I'm asking for a judgment as a matter of law, Your Honor. The Assistant Attorney General has remitted relevant portions of the transcript, Your Honor, that clearly show that there was a discriminatory animus in my probation hearing. I'd like to turn your attention to the respondent's brief at page 22. And the omitted from the transcript, basically, before the omission, she states that she's reciting the judge. To hear, I must impose the 1.5-year sentence. And then there's 4 dots. So she's admitting part of the relevant transcript, and I'm like, what is she omitted here? So I went and took a look. So let's take a look at what she omitted. Quote, "The reason I am doing that."
Mr. Burnham, I beg your pardon, you have 3 minutes. Mr. Burnham, you have 3 minutes.
Wow. So the judge admitted the reason I am doing that is based on, he described as bouncing back and forth from mental health programs, mental health institutions, and being sectioned before. I believe Thompson versus Davis held that is a substantive criminal law decision that doesn't give him grounds to discriminate based on disability. There's an intentional discrimination. The court should take that into its equitable discretion. I've been in jail a year now and under intentional discrimination. The advisory mandamus, Your Honor, OE 142, a special set of circumstances presents constitutional questions about the adequacies of the state remedies available to Burnham. See, the state chose to remove such claims outside the direct appeal process, where the promises of Douglas versus California and Griffin versus Illinois are uncertain, Your Honor. It is within the state procedural rule framework, Your Honor, that the position is being subjected to deficient and unconstitutional proceedings, and it's diminishing my ability to raise the supremacy claims that uncontrolled, undivided power of government has taken my liberty, Your Honor. I requested counsel in motion for fair hearings with specific requests. I clearly stated I would like counsel. No counsel was provided. Also, the defendant, I asked for counsel in request for reasonable accommodation. I also asked for motion for fair hearings with specific requests. These have been denied, Your Honor. And those are reasonable arguments. And the reason for denying fair hearings is simply that indigent defendants are not provided with funds in a civil proceeding. So I would argue, Your Honor, that the initial review collateral proceeding as applied to this petitioner violates procedural due process insofar as in 8 versus Oklahoma, the 14th Amendment's due process clause guarantees fundamental fairness and a fair opportunity to present defense. I would argue that the initial review collateral proceedings violates the meaningful access to the courts. The Supreme Court has held that prisoners have a constitutional right to meaningful access to state post-conviction defenses. I would argue that Rule 30B as applied to this petitioner as a facial challenge violates equal protection insofar as Douglas versus California. How the Supreme Court held that equal protection clause requires the state to provide indigent counsels as appeals as of right. This is, in essence, my first appeal as of right. So I'm going to argue that Douglas, California, I should have had counsel, and that was denied. Also, as applied to the petitioner, it's a discriminatory action motivated by ill will over my protected activity. I would say that also violates equal protection. I would also say that the Rule 30 collateral proceeding also violates the suspension clause, United States Constitution, Article 1, Section 9, Clause 2, because the state has erected egregious access barriers that this petitioner cannot surmount. They obstructed rights to counsel. They obstructed my rights to request the audio, frustrating the petitioner's only available state remedy under effectively may suspend the writ by foreclosing future federal habeas review. It has done so, Your Honor. The Anti-Death Penalty Act requires me to exhaust state remedies first. If those remedies are obstructed, then that's impairing my future habeas relief because I have to seek exhaust state remedies. And I believe there is a suspension clause issue here, Your Honor. And it should be noted that there is other discriminatory behavior. The clerks are willfully
Mr. Burnham, we're familiar with your submissions, and you're over your time, as you can see. So thank you for that. And now we'll turn to Ms. Sullivan. Ms. Sullivan, you have 5 minutes. Or no more than 5 minutes.
Thank you, Your Honor. Good morning, Jane Sullivan, on behalf of the Commonwealth, the Worcester County District Attorney's Office, and I will be addressing SJC-12792, the defendant's appeal from the denial of a single justice of the defendant's 211-3 petition. In that petition, the defendant attempted to challenge the validity, asked this court to review the validity of his guilty plea. And I would suggest that the single justice correctly denied that motion. Relief under 211-3 is extraordinary. It's available only in the exceptional circumstances where there's no other remedy expressly provided. Here in Massachusetts, there is another express remedy, and the defendant has in fact availed himself of that remedy. It is to file a Rule 30 motion challenging the validity of the guilty plea. The defendant in fact did that. The Commonwealth has responded, and in so doing, the Commonwealth filed its opposition, and in so doing, the Commonwealth obtained transcripts of both the May 8th, 2018 guilty plea and the sentencing on May 11th, and submitted copies of those to both the court and to Mr. Burnham in connection with its opposition. That case, that motion is currently pending in front of the Superior Court judge, Judge Reardon, who heard the plea. And in the event that there's an adverse ruling against the defendant has a right of appeal, obviously. Under Rule 30, it would go to the appeals court. He could file for further appellate review. His appellate rights, his rights to challenge the guilty plea are all well preserved within established rules of criminal procedure in Massachusetts, such that the single justice correctly denied the motion for extraordinary relief. And I would ask the court to affirm that decision.
Okay.
Thank you.
Ms. White, you have no more than 5 minutes yourself.
Thank you, Your Honor. May it please the court, Your Honor. Fabiola White on behalf of Massachusetts Probation Services. I'm going to address 3 reasons why the court should affirm the single justice petition. As the Commonwealth has already stated, the petition that was already denied by the single justice, the 211-3. Probation is only going to address that in a limited circumstances and rely on the Commonwealth's resuscitation that the extraordinary relief is the only appropriate reason why a 211-3 would be heard before this court. I want to point to the court that the petitioner did not file anything in the lower court, such as a motion to appeal the probation revocation or a motion to reconsider the probation revocation. So neither of those avenues were taken upon the petitioner, so we'd ask that those remedies would still be available to the petitioner if he chose to go towards that avenue. Second, probation would like to cover the second issue, which is Mr. Burnham, the petitioner, had already litigated this issue in federal court, and the federal court had made a decision, and therefore he would be barred by res judicata to argue the same issues here before this court. And third, that this court's own decision on a parole case and the Department of Justice shows courts do not have to fundamentally alter probation, which is more than what Mr. Burnham is looking for here. So I would go with the second issue first, which is that res judicata is barring Mr. Burnham from seeking remedy in this court. In the res judicata, there's two issues. There's issue preclusion and claim preclusion. I'd argue that there's issue preclusion here where Mr. Burnham argued the very same issues in the federal court, that there was an ADA violation by the probation department, and that issue was litigated in that court, and there was a final decision where the motion was granted by that court. The petitioner and the probation both responded, and that case was fully litigated, and therefore he would be barred by raising those same very issues before this court. Third, there's the issue of the ADA claim where the petitioner claims that the probation officer said that he was not a good candidate for probation simply because of his mental health. That is incorrect. I provided the transcript in which the probation officer simply reiterated that because the petitioner had picked up a new offense and that there is a safety concern to the community and that he had received probation on the underlying offense where those services were made available to him. So when he pled guilty initially on the first instance of the case, he was provided with a mental health evaluation and other conditions of probation that would help him with his mental health to make sure that he received the services and the benefits of probation. Within 2 months of being on probation, he had violated that probation by picking up a new offense. And the remedy that he sought was to be reprobated. And the Department of Justice guidelines do not call for that. If it fundamentally alters the point of probation, which we believe that has done here, then probation does not have to simply reprobate the petitioner, and that's not the only remedy that's available. The petitioner had picked up a new offense where he had thrown a laptop while in a facility, and that's something that the court took into consideration. Also in the transcript on the underlying case where the court sort of went thoroughly, what are the other options for the petitioner? What other services could we provide? Is a GPS available? Is a GPS something that's going to remedy the reason why the petitioner was back before the court only 2 months after being on probation? And the court decided, no, that would not be appropriate. So the court took the necessary steps to determine what other services and programs would be available for the petitioner, and no other services would remedy those issues. As the probation officer stated, the petitioner had never really got started on probation. The mental health evaluation never happened, even though it was scheduled to occur, and so no other services were provided to the petitioner because he's not availed himself to that services. If the court has any additional questions, we'd rest on the rest of the brief.
All right, thank you.
Thank you.
And we'll take the matter under advisement. Thank you.